So that's Sid Miller, and we'll talk to the Minister about that later in the program. Does she have confidence in EQC? We'll ask her. The government's other sometimes contentious presence in Christchurch has been the insurer's southern response. This, as we said, and we'll explore this later too, was the safety net for AMI clients making earthquake claims, but sometimes it was a safety net that said no, or maybe, or That resulted in a class action against it, and today that was settled out of court. In short, a group of 24 customers had argued Southern Response had engaged in a deliberate strategy to deceive them and delay their claims. They've agreed to stop using such language. Southern Response has agreed to stop fighting them in court. Over the next few months, each claimant will meet with retired High Court Judge Sir Pankhurst, who'll settle their cases individually. It's a major breakthrough. Lawyer Grant Cameron has led the class action. A short time ago, I asked him how the settlement had come about.
The parties have got together, have negotiated an agreement whereby the claimants can enter into a private process and get all their claims resolved in a much faster fashion than going through court.
And this is after you've gone through court, High Court, then the Appeal Court.
Yeah, I think the Court of Appeal cleared the way for the action to go ahead, said that everything was fit and proper for proceeding through the court process. And at that point, I think there was reflection on both sides of the fence, and it was agreed that we could move more quickly forward.
Why did it take a trip to the High Court and a trip to the Appeal Court to get to this? And I know that there has been an agreement around the language that can be used now, as is often the case when two parties that have fiercely disagreed agree to agree. But what has preceded this?
Well, basically, the fundamental problem has been some doubt in legal terms as to what a class action may or may not comprise. And so Southern Response took the view that probably in these circumstances this didn't amount to what's called a representative action under the High Court rules, and they wanted to test that. The Court of Appeals now clarified the position and said, yes, it is a representative action. So generally, I guess these people have clarified the law, but the way is clear to proceed through the courts for this sort of case, had that been desirable, but there is a better way of now resolving things.
Grant, it's been a tough, emotional rollercoaster ride for your claimants over a period of years, many years in some cases. Is this the end of it now, or is there still the settlement process to come?
Yeah, they do have to go through a process, but it's a very much more informal process. On one hand, the advantage of the court is that everybody has certainty as to what all the rules are. On the other, sometimes that can be a relatively inflexible process and necessarily will take a long period of time. The particular path that's been mapped out here, we have used before to resolve the Cave Creek fiasco and also another one, Lake Alice, I think about the year 2000. And these were complex sort of cases that, for a whole host of reasons, deserve to be put through a private sort of process. And I think this government has recognised the benefits of doing that for this particular group of people.
Grant Cameron mentioning the government there. We'll talk to Megan Woods later.